Court of Justice on the free movement of persons. And these are cases that would be known even to the least advanced student of European Union law. So these are very classic cases. I've taken these cases in an effort to tease out correspondences between modern-day migration and the descriptions of the migrating patterns of Europeans during the discovery of the New World. From this examination, I have found that the advent of Union citizenship in 1992 marked two distinct phases in the movement of persons. The first phase, that is pre-Union citizenship, saw relatively brief journeys, excursions around European territories, with workers or service providers having little opportunity to enjoy prolonged stays outside the country of their nationality. And this not least because there was little or no social support available. This period could be seen as one of intense exploration and discovery, aimed at destroying or unsettling forms of social life associated with the nation-state. Post-European citizenship, that's 1992 onwards, we see greater opportunities for long-term residence and even permanent settlement in a member state other than that to which an individual could claim nationality. Nationals of member states can now rely purely on their status as citizens to move around Europe. And also have access to emerging social and educational benefits. What we may deduce from this period is the attempted transformation of Europe to the post-national ambitions of the European Union. I decided to test this fairly crude periodization by reference to judgments of the Court of Justice of the European Union on the question of the scope and meaning of the concept of worker for the purposes of the exercise of free movement under the treaty. The very expansive notion of the concept has always been a striking feature of the jurisprudence of the court. Indeed, so liberal is the notion that individuals can claim worker status whilst being required to do very little actual work. For example, in a frequently cited case, so some of my students will know, called Rawling, a waitress had a very informal contract which did not guarantee even a minimum number of working hours. She could go for days or weeks without work, and indeed, after a period of 8 months residing in the Netherlands, had worked for a reported 60 hours. The court, nevertheless, construed her as a worker for the purposes of the free movement provisions. And in another leading case, Levin, the court asserted, and I quote, the right of all workers to pursue the activity of their choice within the community, irrespective of whether they are permanent, seasonal, or frontier workers. And the court was prepared to exclude from the scope of the concept, again I quote, only work on such a small scale as to be regarded as purely marginal or ancillary. Now, I have absolutely no quarrel with the court's conclusions in relation to these individual cases, but would note the obvious, and I think significant fact, that many individuals who, according to the interpretation of the court, who are deemed workers, cannot conceivably settle into work in a sense of ever forming part of a stable workforce. I concluded that these individuals were in reality 1 part worker and 3 parts explorer. Let me elaborate. Cases like Rawling, of which there are many more I could allude to had I the time, entice the most marginal participants in the workforce to set out upon a voyage of exploration and discovery, with the lure of work providing the motivating force. Although work is certainly the inducement that is held out to private individuals to encourage them to migrate, it is not an end in itself. Rawling achieved little by way of her labour, but much in helping to unsettle entrenched ideas of what actually constitutes valuable labour. Her achievement in leaving the country of her origin to settle in another European state is less valuable as a contribution to any economy, and much more in that she, and others like her, were to disrupt one particular aspect of social life, that is the concept and organisation of work. During her period in the Netherlands, Rolin engaged in work for around 10 working days, but was her time spent away from formal labour, idle time from the vantage point of the constituting of Europe? She was, an unsympathetic assessment of European worker movement might conclude, merely taking up space. Less pejoratively, I would say that she was filling up space, and thereby carrying on a necessary process involved in the formation of political community. The advent of union citizenship in 1992 brought about measures that would encourage more lengthy settlement in the territories of Europe, even, as I said earlier, permanent second residence. Yet it remains the case that significant rights within the European Union can be triggered only by the exercise of free movement. Post-1992 citizenship did not place the European citizen who chooses to stay settled in her country of origin on the same footing as the intrepid explorer. The law governing family reunion with a third country national is a strong case in point. European law enables a European citizen who wishes to have a non-European Union family member reside with him or her to do so only once the European citizen has exercised free movement rights. In the absence of the exercise of such rights, only domestic immigration law may facilitate family reunion. The fundamental rights, such as the right to enjoy family life, are not distributed evenly between European citizens, per se, but unevenly between discoverers and settlers, the former being entitled to more expansive rights. I am by no means the first to observe a qualitative difference between pre- and post-1992 migration patterns, and more generally, differences in the maturing of the European polity in those distinct periods. However, whereas I would be inclined to point to the pre-1992 phase as the most significant in terms of political formation and participation, most commentators would locate post-1992 as the point of, I'm quoting, the slow accrual of social and political rights against the overwhelming impulse of economic liberalism. This, to my mind, is revealing of a surprisingly simplistic understanding of the political. In truth, early so-called market-oriented free movement rights were at least as resolutely political, I would argue more political, than post-1992 citizenship rights, for it is through those so-called market-oriented free movement rights that European territories were traversed and thereby transformed. Says Carl Schmitt, quote, "In some form, the constitutive process of land appropriation is found at the beginning of every settled people, every commonwealth, every empire. This is true as well as for the beginning of every historical epoch. Not only logically, but also historically, land appropriation precedes the order that follows from it. It constitutes the original spatial order, the source of all further concrete order, and all further law." The effective beginnings of the European Union can be located in the Rome Treaty. The four freedoms reveal that at the heart of European integration, we see, as we have seen often before, the assertion of the right of European people to move freely across territory. The legal notion of free movement and the practice of free movement that the legal concept authorises remains at the core of the European Union's constitutional and substantive fabric. Those who seek to comprehend the precise legal nature of the European Union make much too little of the undeniable fact that the Treaty of Rome engineered the exodus of the peoples of Europe, lured by the promise of economic advantage, Such projects of migration have lent force to virtually every legal community at the dawn of their existence. Read in this light, the Rome Treaty sits alongside the royal charters, papal bulls, and other legal texts which outline the rules and principles according to which land could be appropriated. The land appropriation has authorised all that has followed. It is often dubbed the axis on which the European Union revolves. The Rome Treaty is the primary law of the European Union, or to invoke Schmidt again, the first measure of all subsequent measures. Now, the Reform Treaty renamed the Rome Treaty the Treaty on the Functioning of the European Union, the treaty without which the European Union cannot function. Hold that thought for a moment and I'll move to the next segment of my argument. The empty spaces of Europe. My argument about the normative status of discovery is not complete. I trust you are able to at least entertain the possibility that the European Union rests upon a nomos, that is a basic law of the earth. But there is more to discovery than a mere taking of or working on territory. This brings me to the second segment of the argument. The complex rearrangement of the European space, which we have witnessed over the past 50 years or so, follows even more closely the discovery of the New World than I have yet revealed. Conceptually and analytically, the discovery of the New World occupies an important place in my work because, as with the development of the European Union, the particular challenge in that historical period was to effect radical constitutional change over territories that were both populated and governed. Can one plausibly speak of the discovery of territories comprised of nation-states of Europe that had achieved, if not an ideal, then at least an advanced state of development? I felt that one could, but how to articulate it was, for me, the stumbling block. So I turned to Peter Fitzpatrick, as often I do when stuck for inspiration on questions of law and coloniality, and found the beginnings of an answer in Modernism and the Grounds of Law. Specifically, the following passage, which assumed enormous significance in the development of my work from that point on. Perhaps, this I'm quoting, perhaps the most compendious point to be made about discovery is that it involves something specifically more than the world's ordinary meaning. What the word normally imports is the uncovering or the disclosure of what is already there. In this sense, the word is contrasted to invention, to the creation or inauguration of what was not already there. However, the prefix "dis" does have a privative force with its connotations, and this is this crucial part, with its connotations of actively denying or undoing a previous condition. What this intimates for discovery is that the thing discovered is now different for having been discovered. It is now denied its cover and put on a new scene, one pertaining to the discoverer. End quote. Long before the European Union came to pass, with the basic law of the Treaty of Rome, there were no earth spaces that had not been covered and governed, populated and organised according to a form of governance. But this was also true at the point of the discovery of the New World, so-called. To be discovered, the territories of the New World had to be denied their cover. The law of the earth can never be displaced simply because of the existence of a form of governance and of a stable population on territory that is appropriated to form the basic norm. The point to be taken from the period of European history known as the age of exploration or discovery is precisely that land appropriation can operate in the face of a world, the separate units of which have once been appropriated, its lands already divided, populated and governed. What that period of history also tells us is that by expanding outward in space, European discoverers were able to perceive themselves as being propelled forward in time. The undeniable fact of land appropriation was combined with the fiction that what was being appropriated was barren or abused, made better, if not whole again, by the discoverer's intervention. Always, discovery is premised upon the existence of a figuratively empty space, a fictional terra nullius, a land belonging to no one. Let us apply these thoughts to the European Union. Most writers agree that European integration was seen as a way there'll be several quotes here which I can't fully attribute with the time, but a way to end the vicious circle of violence that followed the sovereign state. To correct the economic bankruptcy, these terms are in constant use in discussions about the development of the European Union, to correct the economic bankruptcy that was the state of most European nations after the Second World War, and to find an alternative to the calamitous, quoting again, political bankruptcy of the old order in Europe. No longer could be tolerated the, quote, repetitive pattern of bloody conflict between nation-states as a current feature of European politics. So not for the first time, Europeans were embarked upon a civilizing mission. But perhaps for the first time, at least in modern history, Europe sought to exercise the savage within itself. The opposition of modern, pre-modern, of savage civil has ever been invoked to justify radical alteration in the putatively savage or pre-modern situation, often by brute force, but just as often through migration and settlement. If the widely held perception that modernization was the principal goal of European integration is correct, then to suggest that the originators of the new Europe reached for radically new conceptual tools in order to effect the process of modernization, rather than to deploy modes that had been efficiently, although somewhat unethically, achieved modernization in earlier civilizing missions, is hardly plausible. And of course, it is my contention that such modes of governance were not neglected, that it was within a clear historical template that Europe effected its self-civilizing mission. Going back to Schmidt, if he is right, and land appropriation not only historically, but logically precedes the settlement of any new political entity, then the question of how to appropriate an already appropriated space was one that logically was posed at the emergence of the European Union, a polity which indisputably arose from the densely populated and extensively governed territories of the old Europe. And it is here that the doctrine of terra nullius enters to perform its work.